Welcome to episode 5 of the Crypto and the Law podcast. Today we're going to be discussing an important development in the SEC versus Ripple Labs lawsuit and whether or not Ripple scored an important win. So let's get into it. So as the legal fight between Ripple Labs and the Security and Exchange Commission, the SEC, drags on over whether Ripple's XRP cryptocurrency is a security, Ripple may have landed a key blow in this battle. Recently, Judge Netburn ruled that the SEC must provide to Ripple an email containing a draft speech by former SEC Director William Hinman, along with additional records around the preparation of that speech. This draft speech is from 2018 and is on the topic of whether Ether, which is the token that facilitates operations on the Ethereum network, was a security. In the version of this speech that was ultimately presented, Hyman told the audience that in his view, his personal view, Ether was not a security. In coming to this decision, Judge Netburn distinguished between the SEC's internal analysis of XRP, which remains protected under the deliberative process privilege. So again, SEC's internal analysis of XRP is protected, and the personal opinion of its employees, such as this draft email and draft speech by Hinman. And the judge said, the personal views of agency employees are not protected by the privilege unless they bear on the formulation or exercise of policy-oriented judgment. So in determining that the draft speech was Hinman's personal opinion and therefore not privileged, Judge Netburn potentially gave Ripple an important victory. Although the draft speech is Hinman's personal view, and that's why it can be released, and not that of the SEC, it could contain analysis between Hinman and others that will be problematic for the SEC to overcome. However, even if it doesn't, even if the draft speech contains nothing new or nothing dissimilar from the actual speech, it could still be persuasive to the judge and help Ripple, as Ripple can use the speech, the draft speech, and potentially emails surrounding that to argue 4 important things. First, that even though the draft speech is personal opinion, it is the personal opinion of an SEC director and should be given significant weight. This isn't my personal opinion. This isn't, Johnny down the corner's personal opinion. This is the personal opinion of an SEC director. Second, Ripple can ask for an inference or link between the views of the SEC and the views of Hinman, as both parties eventually determined that Ether was a security. Again, these are personal views of Hinman, but they're in line with the SEC. And as a director of the SEC, his views, although not determinative, are probably in line with that of the organizations. Third way they can use this to help. Ripple can argue that Hinman's opinion in the draft speech should be weighted as expert evidence and not simply as evidence given by a layperson. Right? So by arguing that Hinman is an expert in this area, that's why he's a director. Even though it's personal opinion, it should be given significant weight. And fourth and finally, and maybe most importantly, Ripple Labs can argue that it would have been or should have been obvious to Hinman and the SEC that Hinman's speech, whether personal opinion or not, would be interpreted as market guidance. When the director of the SEC speaks out, people listen. It'd be ignorant for Hinman and the SEC to think that people would take that speech strictly as personal opinion and not take some guidance from it. And what this does is it gives further credence to Ripple's fair notice defense. And that's that the SEC failed to provide fair notice to Ripple that XRP would be viewed as a security. If the director of the SEC is coming out and giving a speech, personal opinion or not, that Ether is not a security, then I think Ripple has an argument to say, we could rely on that speech when we were promoting XRP. So again, although this isn't determinative, the production of the draft speech will likely bolster Ripple's arguments and cause concern in the SEC camp. And as this action progresses, we look forward to continuing to providing coverage and to later discussing how this would have played out in other jurisdictions, including our home jurisdiction up here in Canada. Again, article and blog is not financial advice, but strictly for entertainment. Have a great day. We'll talk to you next time.